1% of the option pool does not mean 1% of the company. It might be similar or very close, but it's not technically the same thing. As you can see, a lot of this at the end of the day, beyond just like the numbers and what it means for people, there's a lot of perception value to all of this. Like people want to give options of 10,000. They don't want to give options of 10. And the difference between 10 and 10,000 could be zero if there's only 100 shares of the company versus 10 million in the company. So it's a little bit monopoly arbitrary math at times, but perception is why people pick these bigger numbers. They want to give big round numbers to people. Always use vesting schedules. Even if they're like better than gold, even like a 3-month vesting schedule, just to make sure that you're working well together after an agreement is signed. I remember one client of mine told me that they were using a payroll processing platform. I was like, are you having the employees prepare their profiles? She's like, oh, we just prepare for them. I was like, well, do you have all their addresses? She's like, oh, we just put our company address for everyone. This is a big problem because she's going to get audited big time because that's not their address. That's not what the state or the IRS recognizes as where they're receiving income. People love remote work, but this part of it is not that easy to manage if you're a small company.
Welcome to the Invisible Ink podcast. I'm your host, Shubha Chakravarti, Chief Financial Storyteller at Achieve. Our guest for today is Madhu Singh. Madhu is an attorney, founder, and Chief Legal Officer at Foundry Law Group, where she works with CEOs, startups, and businesses at the intersection of technology, startups, and business law. She's also served as adjunct faculty at the Seattle University School of Business, been a president and is a current board member at TIE Seattle, and past president of Women's Business Exchange. Now, here's Madhu. Hello, Madhu. We're so happy to have you on Invisible Ink today. Thank you for being here.
Thank you for having me.
So we have a bunch of really exciting questions. I know we're going to talk about this broad theme of how you build a startup with exit in mind. But before we get into that, I'm just curious if you had like a highlight reel of common patterns you've seen among founders that eventually plan to exit, good, bad, and different.
Yeah, that's a great question. So the experience is very exciting at the beginning. There's a lot of excitement about the product, about launching, about the team, etc. And I understand that the legal part is not as exciting and sometimes boring and seems irrelevant at the moment because it's not tied to the actual product in the market. And I think there's something to say about that where there's this mixed emotions of, do we need to get everything organized or can we just hold off until the time is right? And I think balancing where it makes the most sense is really why it's helpful to just, even if you decide not to do things right away or do things kind of haphazardly to begin with, to have some counsel along the way, or at least a trusted advisor who can give you some tips on this. The unfortunate thing is that if you don't do things properly, that exit, some of the things you wish you had done is going to could show up and come back and bite you in the end when it comes to taxes, when it comes to diligence, when it comes to responding to queries and finding yourself running all over the place trying to figure this out and fix things, because it's not often like the big ticket items that hold up an exit. It's usually the small little things that companies find when they're trying to acquire you. And then it becomes like, you're getting this big paycheck. Did you strategically plan for it from a tax perspective and from the team perspective, et cetera? And so I feel like the common themes is a lot of excitement around the startup and things like that, and not very much attention paid to the actual structure processes that need to be in place from day one, really, ideally, but if not from day one, shortly thereafter, so that you are set up for success in the future.
And is there like any egregious story, either good or bad, that kind of comes to mind in terms of this preparedness for exit?
Well, I can give you 2 examples just from the last month alone. One sole founder spent so much time like figuring out his cap table, what it would look like in a Series A, post Series B, in so many layers. He just kept wanting pro forma after pro forma and no matter how many times we reminded him, never got us around to signing his stock award agreement. And I told him it cannot be backdated as easily as he thinks. And so he lost a year in that process. And the year is important because when it comes to capital gains treatment, you need to be holding on to those shares for 4 or 5 years at least. And so he lost a year in the process. And now he's annoyed because that happened. And it's not because he wasn't trying to do that. He just got caught up in other things. And another one, he's been wanting to reward his team for many years. And again, I probably every 3 months checked in with him. Can we sign these agreements? Can we move forward? He kept going back. They were talking and oh, I'll get to it. I promised them this, that, and the other. Now we're at a stage where the company is worth millions of dollars. You can't just hand them over shares without creating a big tax burden on them. And now is trying to find a solution using a phantom plan and this plan and that plan. But all of that is going to mean any one of those individuals that he thought of as co-founders is going to take a big hit tax-wise at some point. And so like these things, like I understand the founder wears many hats, but these people are relying on you to be organized. And so even people who have legal counsel, this can still happen to them as well. It's just like when I say egregious, it's like it frustrates me because I'm like, I can't sign this for you. Like you have to like put in some effort in my job. I'm not your admin where I can just run around after you with a piece of paper. Like you have to proactively take responsibility for your company.
And I'm just curious because I mean, I felt slightly guilty myself because I hate paperwork as much as the next person, right? So it hit maybe a little too close to home, but I'm just curious, having seen human nature for so long, do you have any theory on like why that is? Is it just this resistance to what feels like paperwork? Like what, any thoughts on that?
It could be this like, I don't know. I think it's this like fear maybe that it's final or that like, I think it's just because the paperwork looks so dense, unfortunately, that this fear of needing to review it and signing it, although we go through it and they trust kind of the terms and things like that, I think some people who are really analytical, just even despite all that, have this strong desire to understand every little thing. And then that slows them down. And they'll allocate like 2 or 3 hours to review something. Like, you don't need to do that because half of this is just boilerplate that just has to be there. And so I think that it's just like a cycle. And then it's always like, I'll get to it. And once your team is all happy, they trust you, so they just believe it's going to happen. You kind of just keep going and forget to go back and deal with it. So I get it. I get why it happens. And I try to warn people with some of these stories. And I'm more about like a best practices type of person. I'm not trying to like stress people out with this or make people nervous, but sometimes this is just what happens and you have to prioritize certain things for your company. And then especially most startups, they're not building lifecycle businesses. They're building to exit. And if you want to be in a good place when that happens, you have to do some of these things.
Which brings me to a question, like when we were first starting out, we have all kinds of visions in our heads, and I'm not necessarily sure that exit is top of mind. How often are you seeing founders considering exit? And if so, how does it play out in the way they build their startup or how they're thinking about going about things?
I think there's this underlying assumption that if they're going to raise money, that there's going to be an exit at some point, because that's what's in their pitch deck. That's what they're trying to explain why people should invest in them, because it'll grow and they'll scale and they'll be able to do something with it. And so like, while actually finding an acquiring party may not be in the immediate trajectory, it does tie into raising money. So like these things matter even for just raising money, even in the amount of diligence that goes into certain types of investments that you take on is very similar to the diligence that will take place in an acquisition. So that same mindset has to apply there, and even if exit's not on your immediate horizon. And oftentimes startups, more immediate is the desire to raise money and then hopefully have an exit later on. So I would almost say that's a little bit interchangeable, because there's a lot of investors who like want to see everything buttoned up before they'll write you that check.
So it sounds like, the fact that you're going to get these funds, especially from serious or professional investors, is almost like an unconscious, unintentional preparation for being ready for an exit, even if you're not thinking about it as viscerally as you might be otherwise.
Yeah. It's not that it's like 4 years we're going to sell or anything. It's more like these investors are expecting like a return at some point. So
awesome. So I know we have like a few things to cover, but first things first, right? You've got to start with an entity. So let's talk about legal structure. We've seen so much out there: Delaware C Corp, LLC, all of those things. So what are the common entity options for startups, and what should I be thinking about if I'm a founder to choose the right one, if I have an exit in mind, or even if I don't, to be honest?
I think it matters what your goals are for the company. Like if you're trying to build a business and you plan on bootstrapping it, and maybe you bring on a few contractors, maybe you bring on a possible co-founder, and that's your kind of dream to build it that way. And that's totally fine. But the advice for that type of business is very different than advice for a company that's like, no, I'm building this. I'm going to have 2 co-founders. We're going to raise money in the first 12 to 18 months. We're planning on bringing on employees with that money. We need to be able to issue stock options, things like that. Often feel like what is the triggering difference is your financing plans. So if you do have financing plans in the first 12 to 18 months, a Delaware C Corp is highly recommended. There's a lot of perception value that comes with a Delaware C Corp. It's the birthplace of corporate. People find that it's more shareholder/investor friendly because of that. And there's just a lot of common knowledge about it. So people just expect to see that. And so oftentimes, if that's what people are telling me, that's their plan from the get-go, we say Delaware C Corp. If their plan is more like this kind of like bootstrapping model, like things like kind of keeping the team a little bit small, maybe hiring out a little bit, we can discuss other options like LLCs or even different states as a C Corp. Like Washington, where our firm is based out of, is just as entrepreneurial friendly. So like a Washington C Corp might suffice, or a Washington LLC or a Delaware LLC. So oftentimes the conversation is tied around what their initial 12 to 18 month trajectory looks like. And then we make a decision. The thing that you have to keep in mind with all of this is none of these things are final. So some people come, and maybe you probably have heard of this, they start as an LLC because it's easy. You set it up. There doesn't seem like a lot of corporate formalities. Simple, straightforward, no problem. And it's totally fine. It's great for that purpose. And there's nothing wrong with it. Then if you get to a place where you're like, okay, well, things are changing. We're pivoting. We're going to do this, that, and the other. Then we'll have a discussion about what's the best way to evolve your LLC. Maybe it's to keep the LLC and start a new company. Maybe it's to convert the LLC into a Delaware C Corp. And so you have options. And I'm sharing this because wherever you are, whatever you decided, it's fine, whatever you decided. And to make sure you're in a good place for what you want to be in the future, it is worth having that conversation with counsel to help you make sure that you're planning for that. So like some people are not ready to make the investment and the switch over unless there's an investor standing at their door with a check. And I get that. It's totally fine. And the good thing is with Delaware, you can turn things around within a few days. So you can make all that happen within a week. And so knowing that there's like this timeline, you can be strategic about how you make your decisions. I think it's important for people, ideally, they get advice from the front end and make the decision with counsel. But if not, because there's lots of resources and podcasts and stuff online that you can learn about, and then you could do some of your own research. And that's why I find that people sometimes pick different things. But really, if the goal is be like a Series A investment or onwards, you really should be a Delaware C Corp. Anything short of that, whatever you picked is going to be fine. It's just more a matter of, did you pick something that allows you the structure to reward the people on your team that you want to reward?
I just want to push in on a couple of things, which is many of us or many of our founders, we've kind of maybe started this process already. Maybe I formed an LLC because I had an idea and I just wanted to do it. Are there like boundary conditions or irreversible decisions that you would caution a founder about that might preclude them from doing something different than they initially anticipated?
I think the one biggest thing that I caution founders on, regardless of all that could have, I don't know if it's completely irreconcilable, but very close to being difficult to resolve, is making an S Corp election. So an S Corp election is a very specific tax designation. And depending, CPAs and other things will push you towards that for a variety of reasons, because you can save on taxes, et cetera. However, making that election disqualifies you from a potential better treatment in the future called qualified, like QSBS, like qualified small business stock exemption, or like forgetting what the acronym stands for, but the acronym is QSBS status. And so like if you are able to qualify for that status, when you do have an exit, a good chunk, like a large amount, $5-10 million plus, is exempt from taxes. And so that trade-off is really important to assess early on. So if you were an LLC, then you took an S Corp election, then you converted to a Delaware C Corp, it's not clear whether you've tainted your company and lost that exemption or not, because that S was in the middle of it. But if you were a Delaware C Corp and you took an S election because you saw the tax benefits and then try to withdraw it, you might have lost that opportunity for that status. So people really have to make some critical decisions early on, unfortunately, when it comes to this tax piece, to see if it's worth trying to qualify. And more lately, I would say in the last 2 years, all the investor documents I've seen have a rep and warranty in there that says that you have done your diligence, that the company will qualify for that exemption in the future. And so like it's become a bigger deal than it was when it first came out because it's very friendly to companies in an exit standpoint. I, as legal counsel, recommend people go get tax advice on this or tax counsel because it's so specific and can really impact your business, but don't lose sight of that when you're making these decisions.
So if I'm already, let's say I already spoke to my CPA and he or she already said, go be an S Corp, do I have options to unwind it, maybe start a new corporation? Are there things like IP assignment that I need to be thinking about? Just high level, would you give some pointers?
So in that scenario, that's what happens. We start a new company. That's what we always have to do. We end up starting a new company, assign the assets over, and try to make it as distinctive as possible. But beyond just this S Corp status, the QSBS is only designed for product companies, and they cannot have a lot of services mixed into it. They can have a small percentage of services. So like there's a lot of layers to it. I don't want to spend too much time on the tax piece, but it's important to go get the assessment. As an example, my law firm, we're a service-based business, we would never qualify for that status. But if I made some of these legal tech products that exist, they could potentially qualify because it's a product that they've created that qualifies as a product under the IRS code, and they could potentially get that special status.
Fascinating. So I'm just going to ask you one thing. I do understand and appreciate that this is not a tax conversation or a law conversation, but just one thing on that. These days, as I work with more and more founders, I'm seeing a lot of hybrid businesses where there's a hardware component and a software component. And I'm also seeing a lot of things which in theory could be services, but that are sold as products, right? Let's call them productized services, right? I give you a box and say you get the following things. Is there any clear guideline on that a founder should be thinking about as to what's the product? Does it have to be?
That's something that they would want to talk with a tax advisor to just see how the IRS code interprets those types of things. Because if it's like a subscription, maintenance, that type of stuff, sometimes that qualifies as long as it's not as long as it's like under a certain percentage threshold of the business. So there's like various thresholds that come into play and things like that are important in that discussion. But purely services, like a law firm providing services, is different. That's very obviously not excluded. But to your examples, all of those could potentially be favorable in that circumstance.
Got it. So now then, if I've come back and I've already created an LLC, or if I have to decide between an LLC or a C Corp because I'm not sure if I'm ever going to get funding, what are the pros and cons outside of the investor treatment? Are there big cost differentials I should be thinking about in terms of a C Corp versus LLC, and also any administrative burdens like having to file things or conduct meetings and things of that nature?
Well, the LLC is the simplest. It doesn't have a lot of formalities, and most states have really robust LLC acts. So if you kind of set it up and don't do a whole lot else, you'll be in pretty good shape for that. If you do have a partner in an LLC, it's very important to have an operating agreement to just lay out the fundamentals of your relationship, management, buyouts, etc. A single member C Corp, it seems like it should be just as easy, but unfortunately it's different because as a C Corp, as a single founder, you're wearing multiple hats. You have a hat as a board member, you have a hat as a shareholder, and then you potentially even have a hat as an officer. And so while you might be one person wearing all three hats, the C Corp is expected to have some formalities. Like you're expected to have an annual meeting. It's required by most state laws to have an annual meeting and things like that. And so often that's what we're recreating in due diligence is annual meetings that never took place because people are like, what, I have to have a meeting with myself? This seems silly. Like it's more practical when you have like a group of people and it makes sense and you get that. And so like that's the thing is there's more administration when it comes to a C Corp and being mindful of which hat you're wearing in that particular circumstance. So I would say a C Corp tends to be more administrative burden-wise. Legal fees are not too far apart. Filing fees are not usually too far apart either. But economically and more efficient and providing the same liability protection is really an LLC. I think it's a great construct. And I understand why it doesn't always work for some people, but it's really great for a lot of other people, like consultants, like some IP businesses, wellness companies, law firm. There's so many great places for it to be useful. But in the context of a more tech-forward startup, it's not the best fit.
And I want to clarify one last point on this LLC, which you said Series A onwards, you really need to be thinking about having a Delaware C Corp. So are you seeing deals where founders are getting funded on safes or convertible notes, whatever the structure of the instrument is, pre-Series A with an LLC corporate structure and still be okay with it, like with professional investors or semi-professional
Yes.
investors?
Yes. It depends. It does happen. It has actually happened quite a bit, more than you might be like expected to, but there is often a clause in the term sheet that prior to the priced round, for example, the conversion will take place. And so like in the interim, they're fine with it being an LLC, et cetera, but there is an expectation, there's some documentation or some written part of the agreement or understanding that conversion will take place into the future. There's not a whole lot of LLCs that exist beyond that. What's
Got it.
interesting, though, like private equity, they tend to be LLCs, and private equity investor groups tend to be LLCs. And so it's interesting where it kind of shows up in different capacities, but it is very possible to receive funding in LLC, completely feasible, convertible note, safe, whatever. But the caveat to that is that there is this expectation that down the road it'll be converted should it need to be.
Got it. And then I want to round out one thing on the corporate structure, which is you've already talked about why you got to be really careful about an S Corp. I got that. So assuming we leave that out from this discussion for now, I assume you just have to start over if you're an S Corp already. But if you're an LLC and you're trying to make that decision now that you're no longer going to be just a bootstrap, you're thinking of getting money, what is the right time that you recommend conversion? Is it, as you said, just wait until you're sure of the money and then go through the hassle? Or are there other factors I should be thinking about?
That's a great question. I actually just had this conversation today. Most people, it depends on a few things. The common thing that it depends on is like whether or not they're really going to raise investment. And so whether they're very close in their conversations or not. And then we pull the trigger on doing that. The other thing is the incentive for employees. So some people, they want something in writing for their team that says that they're going to get it. And in practice, you can set up the equivalent of an auction pool in an LLC. It just functions a little bit differently. And so then people just need to decide, do they want to make the investment in making their LLC work for that purpose?
Mhm.
Or is the money better invested to go ahead and convert? And so because the plan is to do these things in the future, and oftentimes because of how it can be rather complicated on the LLC, and knowing that they're likely to convert in the future, they make the decision to just convert. So it becomes a balance of the timeline, the fees and legal fees involved, and then the potential for investment to make those decisions happen.
Although it sounds like you've kind of made the decision by default, right? Because if you're talking about equity being a significant part of compensation for any early employees, the expectation is that you're not going to be a bootstrap company, right? I mean, that's kind of a decision that's been made by default the moment you start talking about, okay, I'll give you equity. Because otherwise there's no liquidity for these guys.
Well, in theory, there isn't, but I guess there could be because like you could bootstrap it to success and sell the company and then they would get cashed out that way.
Sure.
So like, it's not necessary that, but the thing is, if you're because some people are fine, like in their offer letters, it'll say like, when we make the conversion, we will issue these options. Like they kind of outline what's going to happen, but it's going to happen at some point. And so some people drag that out for however long. And I don't think it's a good idea to drag it out because it becomes empty promises and you create this disconnect between your team and you are trying to make up the salary by giving them incentives, but then not actually giving to them because you're not investing in making it happen. So I feel like truly you should just set it up when you're at that stage of bringing on more people that you want to reward with equity. So that's one option, or at the time of investment. And they might be the same time, they might be different times. But those are two big trigger points that I think a conversation must be had as to whether or not it's going to happen that way.
That makes
Because when
sense.
people try to get incremental like LLC units and things like that, converting that becomes an expensive administrative and legal endeavor where you could have just set it up this way. The last thing I'm going to say about this is the LLC can still be useful. The LLC we've seen can just hold the IP. The LLC could be kept for services. It could be like wound down. It could be used for something else. It's not like completely wasted, or you convert it. Like there's many options you have. So like, that's why I said, realistically, none of what you've decided is going to necessarily be wrong. It's more like, are you set up for what you want, where you see your company going? And then it might be worth to be mindful of some trigger points during that journey where you should reconsider whether the structure you have is satisfying your goals for the company.
Got it. And outside of the legal entity, are there other formalities relating to formation that founders should be
cautious about or aware of that we haven't talked about?
Yeah. So like you will have to file articles of incorporation in the state that you want to incorporate in. Then when an LLC structure, an operating agreement functions as the main agreement that outlines management, record keeping, accounting, buyouts, et cetera. Everything's in one agreement. In a corporation structure, there's a set of bylaws that provide governance on the roles the board members play, the roles the shareholders play, what constitutes a quorum, board meetings, requirements, et cetera. In addition to that, there's going to be a separate agreement that describes the stock that you're receiving. So it can take the shape of a stock issuance, a restricted stock agreement, a subscription agreement. They kind of have like various terms, but at the end of the day, it's a document that documents the stock that's being issued to you as a party to this company, as a shareholder to this company, and any restrictions that come with it. The common restriction, as you probably, most of your audience is probably aware of and yourself, is vesting and some form of vesting. And vesting simply means is you're not realizing the full value of the shares you received until some period of time or some conclusion of what is associated with those vesting terms. So those shares are yours, they're on reserve for you, but you don't get the full value of them until some future point of time. Time-based vesting is the most common, like you earn against it year over year, month over month, whatever you've decided. There's occasionally milestone vesting. People like to do that if to push for a launch, like or first customer, that type of thing. So there's a lot of ways that vesting plays into it, but vesting is incredibly important for a variety of reasons. I would say the number one reason vesting is important when you have more than one person in a company is to show the commitment to the company and to each other. And so while you two founders could be best friends for lives, it doesn't mean they're best business partners. And you have a mechanism in a vesting schedule called a cliff period that allows people to make sure they're a good fit for the company for a period of usually a year before the first trigger on the vesting schedule starts. So in an example, let's say, Shubha, you were going to get 1 million shares on a traditional 4-year, 1-year cliff vesting schedule. So that would mean 25% would vest after the first year anniversary. So on day one, you have 0, but on day 365, you're going to have 250,000 vested, and then incrementally after that over the next 3 years. So if for some reason it doesn't work out in that year, you're not walking away with any part of the company. Because if you leave, it doesn't work out, we go our separate ways, you cancel the shares because they haven't vested, and then you can kind of hold on to the company, and it gives everybody time to, and it's good for both people to do that for each other, even if you're the person who had the original idea. It's a way to show commitment from everybody's perspective. The other important thing is even if you're a sole founder or the expectations, you still have a vesting schedule because investors want to see that commitment. Investors want to know that you are also equally as committed, that even though you're the founder, you're the idea person, you put in the first money, etc. If I'm going to give you my money, I want to make sure you're committed to the company and you're only getting your full value of the shares at some future point of time when the vesting has completed. But it's a way to measure each other. That's probably the biggest thing that I have seen in my years of practice, besides the other stuff we talked about, where people get frustrated, is a falling out amongst founders, a falling out amongst teammates, and then some arbitrary person that's no longer associated with the company somehow holds on to 1, 2, 5, 7% of the company, and they can't figure out how to get them off the cap table, and they're stuck because they didn't use a vesting schedule to protect themselves.
Got it. So to kind of round out our last discussion, it sounds like the main kinds of documents you talked about were kind of like the formation documents, which is the articles of incorporation, and then kind of like here's how we do business, which is the bylaws and so forth. And then the third piece is around how we'll do the day-to-day, roughly speaking, which is the operating agreement. And then you came into this really important topic around vesting and equity. So let's just build on that and talk about kind of how to use equity to grow your team, because you touched on a super important topic. And then I want to go back later to due diligence. So obviously equity is a big part of attracting high quality employees early on, and you cannot pay them a lot of cash. What, from a kind of high level perspective, if you're the founder or a co-founder, what should you be thinking about as the top factors in setting up a good equity compensation plan in addition to vesting? We already talked about vesting.
Right. So like vesting is really important. To your point about summarizing, so like you need governing documents for any entity. So the operating agreement and bylaws, operating agreement for an LLC, bylaws, and articles for a corporation are like must-haves. And then you need some way to indicate that someone is a shareholder. So the common way to do this is restricted stock agreement, which we just discussed, where you have these parameters around it. But outside of those parameters, the only other thing that's in there is here is your shares and they're in your name. And here's the stock ledger that shows your name. These days, no one uses certificates. Like most of the time, there's not this fancy certificate. If you're using a cap table management tool, you might get an electronic certificate and that's that. But then that's kind of at the founding level. Then when it comes to the team and hiring employees and the rounding out your team, it becomes a big discussion as to whether or not what percentage of the company you want to give to them, whether or not you want to give them stock options or restricted stock. And what does that ultimately look like for an incentive plan? And so I think that the way to think about it is like how key they are to your company. So certain types of employees, like key personnel, maybe it's like a CTO or number two to a CTO, or like a chief marketing person or VP sales, like high level people will probably negotiate for a little bit more that are critical to the success of the company. Not to say not everyone is critical, but there is a difference between who would probably be key versus not key in this scenario. And the folks that are maybe not key, reserving some equity for them as well, because people want to feel incentivized for the growth of the company. And so most people, like everyday employees, would probably get anywhere from 0.1% to 0.25% to at most a half. And you do the math to figure that out. And then beyond that, for people that are more than that, they're looking anywhere from 1 to 2, maybe 3%, depending on how great they are. And in some cases, maybe more than that because they're critical to the infrastructure. For example, I worked with the founding team. They didn't have a technical person. And so they need a technical person. They're not going to get investment or do anything without them. So that person's able to ask for quite a bit more. He's going to ask for 7 to probably 12%, is what I told them to be prepared for, because their function is important to the success of the company versus, I don't know, maybe it's just maybe a salesperson, because the other two people are not technical and they have to cover that role. So it becomes part of what you can offer to offset the fact that you don't have as much cash to give them and what the open market would give them. So it's an important tool. It's not the only tool, but it is important for people to feel like they're part of it. I think where people get hung up is like what the percent actually represents. And so as much as we all love math, this is probably the most math you're going to have to do, is people get confused as to the percent of the company they own versus the percent of the option pool they own. So 1% of the option pool does not mean 1% of the company. It might be similar, very close, but it's not technically the same thing. And dilution is really important because as people are coming in and out of the company, people are going to get diluted, and being mindful of what you're receiving from the employee side is really important. And how the employer pitches it to them is also important because they're going to ask questions. And so they need to be prepared for that.
Before we dive back into our conversation, I want to tell you about Seed to Success. Seed to Success is our community letter with our proprietary insights on startup financial storytelling, tips, new episodes, and much more. If you find these discussions helpful in your entrepreneurial journey, use the link in the description to subscribe to Seed to Success today and get all of these and much more straight to your inbox every week. Now, back to our conversation.
Okay, so I want to dive into, you brought up a lot of really rich themes there, and I want to dive into a few of them in particular. So the first thing is you talked about is what are good benchmarks in terms of how much you can expect to get. And those percentages you gave, like the 0.5%, are they off the option pool? I'm assuming they're off the option pool. Are they off the company?
Yeah, those are from the option pool. Yes.
And what's a good benchmark if I'm a founder, let's say at pre-seed? What percent, like how do I look at the option pool relative to the overall ownership of the company? Is that 20%, 30%, less than that? Like how does that relationship work?
Oh, that's a great question. I would say most often we try to keep it as close to 10% as possible. I don't usually recommend going beyond 15% at a pre-seed stage. And you kind of benchmark it based on what you're seeing your staffing going to look like and how much you're going to offer them. Because it could get recast in a potential future financing round, and that's fine. Or if you have enough options, that's fine too. But 10 to 15% is usually the benchmark for that. And then people's options come out of outside. But like the word option is really important here because it's literally the right to purchase these shares into the future. It's not a grant of those shares on day one. And so the other thing that companies get hung up on, because They're like, wait, I don't want these people to have to pay for these in the future. Well, technically they're supposed to because they have to create some basis in it. However, the value, the strike price of each share should be at an early stage rather low. So it should be like a nominal amount. As the strike price gets higher, however, then it becomes like a big decision as to what that will really look like. And so some companies will bonus their employees to help pay for it. Some companies will loan the money to help pay for it. Some people wait till the liquidation event to exercise so they can offset it with the money they're receiving. And so there are things to way to handle it, but you have to have a strike price associated with it. So at an early stage, strike prices kind of feel a little arbitrary because you're just like, where did this price per share come from? But there are some tools out there that can help you navigate what those are. But ultimately, you're likely to get a 409A valuation at some point. And that 409A valuation will look at all the different market factors, where you are placed in the market, your current revenues, your potential revenue, and spit out a number basically for you. And then you can rely on that. And the 409A valuation is what you do that so you can be audit proof. And so the IRS also agrees with you that what the strike price that you want to do. So because what you don't want is like a company that has, let's say, I don't know, $10 million in revenue, trying to give out stock options to its employee at 0.001 per share. And that's not going to probably pass muster unless, there's some real justification that's not going to get flagged. So you get these valuations so you can minimize those risks.
So am I understanding correctly that, you conduct a 409A valuation and you get let's say the price is $10. What is typically the relationship of the strike price, which for those of us who are not familiar, is the price that the employee has to pay to exercise their right to buy the share, to the 409A valuation? Is it a 1-for-1 or is it a percentage of, like, if it's at $10, my strike price is $1? Like, how does that work?
No, it's a 1-for-1. So if the strike price comes out at $10 per share, that's what it is. But for early stage companies, it's never that high. It's usually anywhere from like I've seen some of companies I'm working with that are probably at the Series B side of things. They're like at $1, I don't know, 25. We're not talking $10 at this stage, but $1.25 adds up if you have 10,000, 20,000 options.
Yeah.
So, but most often for like pre-seed, early customers, it's going to probably fall within the 2 to 8 cents format. That's just like, don't hold me to it, but that's just generally speaking, that's usually what comes up. But the 409A valuation will give you that information. The timing of getting that valuation is important too, because there's factors that surround that as well. So I'm not saying that you need legal counsel for everything, but helping you make some of these decisions is part of it. There's a lot of really great resources on how to think about it as well, because some people don't want to pin themselves to a valuation too early on, or pin themselves to a valuation when they're in the middle of fundraising. And so like that, and if you have that report, you have to give it it's going to be requested of the investor. And then you've basically given them a report of what the market valuation is, where you might be trying to be pushing for a higher one, So like timing does matter for some of these things as well.
So it sounds like if I'm a founder, I know that I'm going to prepare for an exit one day. So I'm looking at using equity as a compensation and incentive tool. It sounds to me from listening to you that I have to first make a call. Am I going to give restricted stock or am I going to give options? Right? I know we talked about options. Did you have anything to add on when I would choose between restricted stock versus options, or is it always typically options?
Well, wherever we push for options mostly, but that's not to say restricted stock can't be used as well, because there are some companies that prefer to use restricted stock. Restricted stock is basically making the grant of stock to the employee. The 409A valuation, if you have one, would still apply then. You would own those shares. You would not have to exercise them at any point in time. You will basically have done it already, and they would have a normal vesting schedule, etc. Our recommendation is usually to reserve restricted stock for key employees you're trying to attract to the company, because that is can be a better deal for them than options. And so like, if you're like, Shiva, you're like, and I'm like, I really need you in my company, all this stuff, but you're like, no, I really want to do restricted stock. We'd probably make it work for you to get the restricted stock so that you could have that, because we want you to be there in the company. And there's many reasons why you would have pushed for that, because of all the value you can add. But short of that, everyone else should be coming out of the option pools, not just employees, advisors too, potential consultants, things like that. We really are pushing for them to be out of this pool of shares, The reason being is that you've set aside this pool of shares for this purpose. And the pool of shares can include both restricted stock and options, by the way. But the pool of shares is set aside so that when you look at the rest of the cap table, it's factored in. So even if you don't use it all, at least you know it's all factored in. And so you know what your percent of the company is, fully diluted, taking into account the option pool that's been set aside. There's not often a lot of restricted stock that comes out of the option pool, but it can often be there. And the other reason people want to do that is it helps keep their cap table clean. You'll have 2 or 3 founders, maybe one investor, and then an option pool, and it'll just say like 12%. And nobody is looking at all the different names in there, just looking at it. So as you can see, a lot of this at the end of the day, beyond just like the numbers and what it means for people, there's a lot of perception value to all of this. And people like perception, like people want to give options of 10,000. They don't want to give options of 10. And the difference between 10 and 10,000 could be 0 if there's only 100 shares of the company versus 10 million in the company. So it's a little bit monopoly arbitrary math at times, but perception is why people pick these bigger numbers, is because people always pick 10 million shares in their company or more because they want to give big round numbers to people. So it sounds like it just feels better than 25 versus 25,000.
Got it. So then it sounds like, you go in there, you have this ingoing hypothesis that you're going to have a clean cap table, you set aside this option pool, use restricted stocks in extreme moderation only when you need it, right? And then you talked about what percentages you give and to whom you give them. What are the do you increase it over time? Like, how do you manage this option pool? And what else about using equity as compensation do I have to keep in mind as a founder?
So like these days, it's really great that these new companies are out there helping us manage those things. Like there's Carta and Cake and LTSE, there's lots of them out there. And so you can find the one that's right for you. And why it's useful is like it creates a place to issue the options from, send out the documents for signature and track them for the employees and do people can go check their vesting schedules, they can do their exercise, they can do everything on these platforms now, which is really useful. But the thing to keep in mind is like any sort of incentive, even bonuses, there's some like annual review component to it. So after a while, people will have gotten diluted because maybe you increased the option pool size, or maybe you decreased it and things have changed. And so to kind of offset that, you do refresher options or you do promotion options. You keep using the option pool as part of your annual compensation bonus or consideration of that employee. So it does come back up because people might get 2 or 3 different awards over the course of their employment with you because of these different circumstances. Or in one more recent negotiation, one of our clients did for, I think it was their Series B investment, they, as part of the term sheet, there was an expectation of refresher options for the founders because the investor was like, we need to keep all these people engaged. And so it continues to be used as a tool even for the founding team in the future, which is really interesting because I don't think people realize that it can come back up later on to increase the founders pool because you might have given up a lot of equity in financing rounds, but it might be a way for you to capture some back in the future.
That makes a lot of sense. We had another guest on our podcast a couple of weeks ago, and she mentioned that most of the value from her exit came from these additional options and not from her initial stake because she just didn't know enough going in about all these things and she had to make up for the work and the value that she added. So that's a point well taken. There's one other point which you talked about, but I want to talk about 2 things in respect to what you just talked about. The first is this concept of keeping this option pool as a living thing and that you have to keep revisiting it. So is that something that the founder does on an annual basis with maybe their CFO and the lawyer? Like, how does that happen in real life? What's good practice around that?
In real time, it's usually happening internally, like with a CFO and their HR, like what they want to offer people. As a lawyer, my job is to they send me the information that they're thinking. I just provide an opinion on okay, this is likely what the end state will look like. Is this what you had in mind? Or we recommend you make this adjustment because of market circumstances or whatever. And then our job is to document it in a board consent and then help facilitate the issuance. So all of these decisions you make at the option level all require board approval. So back to the kind of the overall topic of diligence, this is one area that people flounder the most. The one area I'm always correcting is they will always check for every single option award. You could have like 200 people on there. Is there a corresponding board consent approving that option issuance? And if there isn't, they will call you out on it and you'll have to figure out how to fix it. And so it happens all the time. It's actually like rather nerve-wracking for founders because when it comes to you from an investors counsel, which is usually a big law firm, and it comes off to you as if it's a really big deal and it's very nerve-wracking and things like that. So oftentimes I'm like, okay, just relax. Happens to everybody. Not a big deal. We will fix it. Everything will be fine. We can show that you guys had a meeting about this, that, and the others. There's different things to do. And at worst case scenario, we do a ratification correcting what happened. And it's totally fine. But the problem is, I feel like this hypes up people is because investors counsel is usually a big law firm, and which is fine. Big law firms are great for things, but they have a lot of associates whose task is to find like any hole possible and any T that's not crossed. And so when you see the list, sometimes you'll get a list like this big, sometimes this big. At the end of the day, it's hardly anything. It's all something that could just be like, all right, fine. This was an error. This was a typo. Here's that, and everything is fine. But don't let that anxiety, it's a lot because you're like, is this going to be a deal breaker? I don't know. But I would say the number one thing that people do not have well organized is a corresponding board consent to go with every option. So
we'll come back to that. I know we have a bunch of questions. I just want to talk briefly about this question of debt equity. I've heard some cases where there are 2 co-founders, 3 co-founders, something happened, change in direction, one left, and they still have their equity sitting on the cap table because they were granted those shares and nobody thought to come up with an agreement early on about what was to happen. Have you seen this a lot? And if so, how do you recommend founders address this either retrospectively or prospectively is easy. You have an agreement, a founder's agreement going in. But retrospectively, how do you deal with this if you have not had that and a co-founder leaves and their equity is sitting on the cap table?
Unfortunately, it happens more often than I would like it for it to be, even against people not taking my advice on a vesting schedule and then upset that they're in this situation and what to do about it. So all you can really do is try to negotiate with them and see if they're willing to forfeit some of their equity. Sometimes people are willing to do so because they're like, yeah, I left, I'm not doing anything. Or they come to an agreement to reduce it, or they come to some sort of buyout and buy them out of their shares. They try to do something. If that doesn't work, we've had a few times where companies have just decided that it was enough of a nuisance that they had to start over. And so they started over completely. And I don't, there's still a risk that those founders will come back and say, well, all you did was start over. That doesn't count. I still have equity. That risk will always be there, but they're willing to take that risk. And so they have to evaluate the exposure points and they just start over without those people. Then there's the impact of dilution. Well, yeah, they will get diluted, but you can't just dilute one person in a silo. Everybody gets diluted. So how much can you expand things to dilute them down without really both diluting yourself and then trying to reissue yourself options to make up for it? It becomes very complicated. It can be done. People have done that too, where they diluted everyone. And then the two founders who were still there got options issued to them or got more shares issued to them to make up for the difference. And all this math is happening to make it all work. And so the thing is, all of that could have been avoided if there were some parameters on what a vesting would look like, what the terms would look like, what a buyout might look like. Nothing is 100%. Best friend, spouse, whatever, is never really 100%. So you really have to still be mindful of these things early on. So there are ways to, manage the issue. Ultimately, we try to encourage people to go with the first one and try to negotiate something with them because it's always better, or just deal with it. You got yourself in that position and you're just going to have to deal with it. And that's that, And we've had, there's been at least one instance where the company was very valuable and what the investor opted to buy them out directly, the founder who held the shares, because he wanted those shares. And so that worked out great for them too. It's that's a possibility too, where the investor comes in and solves the issue as well.
Got it.
But people let it linger too much. That's the bigger problem, is it'll be a founder from 5 years ago. And I'm like, how have you not addressed this in 5 years? And they just put it on the back burner because nobody wants to have that difficult conversation until it's going to come back and bite you because something big is about to happen. for your
Yeah, it's getting
company.
more and more valuable over time, right? So you're just letting it
Looking
balloon
for
into
the opportunity when it was not worth much to really settle that. And that's the time to do it.
Got it. So to round out, before we go to due diligence, to round out in terms of using equity, what do you think are the top 3 things that a founder should keep in mind as they plan on using equity to hire their team or to incentivize their team?
One thing I didn't say earlier, but I would strongly recommend, don't use only equity to incentivize the team. It should be some cash component plus equity for that particular person. If they are a W-2 employee, it has to be cash and equity. But if they're not, then you still should consider that as your marker. Make sure you're being mindful of how much you're offering them, and stay within some of these recommended percentages or do some research, because you do not want somebody to walk away with some change that you're not ready for them. And always, always, always use vesting schedules wherever possible, even if they're like better than gold, like you still, even like a 3-month vesting schedule, just to make sure that you're working well together after an agreement is signed. It can be done. Whatever the term is, it's worth it to you to make sure they're a good fit. So like always use a vesting schedule for these things. One thing I will add, since just as a cover to all this, because we did talk about one tax component earlier, is all of these shares, and we talked a lot about vesting and restricted stock and options. There's a tax form that kind of comes with it called an 83B election. Just remember those words, 83B, and make sure you look it up what it means, and that it's really important that gets addressed. And that's part of the reason you can only fix so much, because an 83B election is a time-based thing that you tell the IRS when you receive the shares and when your vesting schedule started. And it has to be 30 days from when you received those shares. And so like going back, like that example I gave earlier about a founder who waited a year to sign his documents, he couldn't do anything about it because he just now told the IRS that he had received them. Because if he didn't, he would have missed out on that election. And that election is incredibly important for the value of his shares. And so it's like the legal piece is very important in all this, but so is these tax elements. Because while it seems like you're getting nothing, as soon as those shares are worth something, to the IRS, they're worth something always. Like how much they're actually worth and what taxes you owe on them is what you want to strategically manage as you grow your company.
Got it. Those are good points, and thanks for outlining those. So I want to close out with a conversation on due diligence, because all of this comes to roost when you're doing due diligence. We'll talk about due diligence for fundraising. What is kind of like the highlight that we give on due diligence for a founder who wants to eventually exit?
We always try to recommend our pitches that will help you plan with diligence in mind, like kind of keeping yourself organized in a certain way. Oftentimes data rooms are requested of you. You can go online and see what does a data room look like. And you can just start from the beginning, keeping your files organized in a certain way for that purpose. And those things help quite a bit when you're getting to this stage of raising money and things like that, or going to an exit, because they're going to want to see all the customer contracts, all the stock agreements, all the capitalization, etc. But having good corporate records, that's the hardest one, as I mentioned earlier, because even if you have a team, even if you have a board, being mindful of getting a written record of all of that is very difficult to do if you don't start that process early. If it's not a habit you have, you need to make it a habit. Like you need to document your board meetings. You need to have an annual meeting. You need to have these things. Investors are really great about pushing their founders to do this when they have a board and things like that. But if it's just you and this is your first time doing it, it's not that easy of a habit to take on. But I will tell you that it's often the corporate records that is the biggest glaring hole for most people. And as well as their customer agreements. If they don't have them, or if they have them, but they pulled them from ChatGPT or whatever, and so they're not great agreements. The other thing that comes up often is like their intellectual property, because maybe they had some vendor overseas or some vendor locally or a contractor help build the IP, but they never got any IP assignments. There's a lot of things that go into due diligence, because the acquiring company is, I'm going to buy this from you, and I need to make sure that when I buy this for you, there isn't these lingering issues that's going to come back and impact this to me. And then on the selling side, like you're selling a company, there's going to be like 30 representations and warranties that you have to stand behind when you sell your company. Everything from the capitalization to the contracts to the IP to the data security, everything is covered. And you're telling them that you ran the company well and there are no holes. And if there are holes, here are the holes. And then like you're selling the company. You do not want that to come back and show up a year and a half or 2 years later to create a problem for you.
Okay, so I get the very clear picture that it's kind of like about keeping your nose clean, keeping a house clean, and you want to do that from the get-go. I'm a solo founder. Maybe I'm a C Corp, maybe I'm not, but I have to have all of these things done, and I'm trying to run a business and launch a product at the same time. Practically speaking, what can I do, and what tools or advice or other suggestions do you have for me to actually make this happen in real life versus like in the ideal world where I'd have all of these documented?
So that's a great question. What we try to push people to do is every year you have to renew your company wherever you're located and use that date as the time to address these things. Like use that date to have your annual meeting. If you're working with us, we often try to include like just a frame template for you to fill in and keep. If you're working with other counsel, ask them to do that. Whoever your registered agent is, you have to renew the company every year. So use that as that point of time, calendar it, and just do your own little checkbox. Like, do I have all my contracts? Do I have all my employment agreements? Are there new members to the board? Anything changed? Just write it down. Even if it seems silly, like an agenda for that matter, a bullet pointed agenda, at least you've written it down and it's done. For me, the most practical time to think about it is when you're renewing your company. Because they ask you, what is your address? Are there any new founders? Like, is your business still the same? Like different states ask different things, but it's an obvious time, I feel, to do that. The annual franchise tax for Delaware is due in February of every year. And so that's the same regardless of when you incorporated. So some people like to use that as their time to do that because the franchise tax report in Delaware requires you to list all the shareholders, the number of shares issued, the gross assets. And so that's another great option. So like one of these two. So tie it to something functional you have to do for your company in renewing it. If you leave it out kind of in the abyss where it's like, when am I going to prioritize this? It won't happen. But if you tie it to something that you have to do to keep your company going, it is more likely to happen.
And even I may or may not be guilty of this, but you kind of realize that the filing date's coming up and then you just get with it and move on, right? So is there a way to make it easier in terms of, for example, you said they're working with you, then you have a checklist or a template. Are there other resources that you're aware of that would work for these founders to kind of make that a little bit easier that you might recommend?
I think some reason, but I don't again, it's like, I know they sell you these packages and stuff like that, but it's another expense. I don't know that you need to take on that expense. I think people are just better off calendaring it for themselves. And if they miss a year, fix it for the previous year. Use the opportunity if you work with counsel or if you use a registered agent service, some of them offer that as an add-on. If you know you're not good about keeping those things, know yourself and pick what makes sense. I don't think it always makes sense to just have your attorney do that because legal fees can be much higher than kind of some of these platforms that offer these services. So for some of those things, I think it makes sense to use tools that are available to you. But these logical points in time is probably the best way to do it, if anything else. If it's just a solo founder, those kind of become easier. Once you start having more people, it becomes more sensible to have a meeting or you're, keeping track of hiring decisions and board decisions and things like that. And so it becomes more normal for your company to do that type of thing. But short of that, on your own, I think I would just tie it to these things.
Got it. And then I want to talk for a little bit in terms of the substance of due diligence, right? You mentioned a bunch of things. You mentioned shares, you mentioned hiring decisions, employee contracts, customer agreements, you mentioned IP. Do you want to touch briefly on those and talk about what it is that investors look for and where you find founders kind of tripping up the most?
Sure. So on the capitalization piece, we've talked about it a lot. It's usually that board consent matching the options and the share issuance and then the annual meeting minutes type thing. For the other pieces like customer agreements is more like, do you have them with each of your customers? And then in your agreement, are you allowed, depending on the deal structure, to engage in this transaction without it impacting the contract? And so there are some contracts that are out there, like if you have an enterprise client, they consider a change of control or a sale of all your assets as an assignment, and they do not want you to do that without their consent. Certain companies, they don't consider those change of control type things as an assignment. So you just give them notice or you don't even tell them. And so if I am doing due diligence for a company, I'm always looking for those clauses. Like I'm looking for if there are any things that could create a barrier to us fully assuming the contract. And those things that require consent do create that barrier. I want also looking to make sure that all the IP pieces are cleared in those contracts and that there isn't some funny non-compete or non-solicitation that could create a problem. So most attorneys are doing this like kind of contract reviews looking for these 2 or 3 key items. On the IP assignment piece, it's mainly making sure that the company has full ownership of all the IP. If they have a patent and they got some work done from like a contractor overseas, but don't have any documentation of it, that's going to be a problem. So they'll have to go back and get that documentation or get that assignment. And so we're looking for those kinds of things for the IP assignment component of it. Employment is a little bit more straightforward. Like, do you have good employment records? Have you been running your payroll properly, paying all your taxes properly, doing all those things? One of the things with the remote work world that has made that part of diligence really difficult is the people are not using their correct addresses. So like if you, for example, if we're all in Washington but I'm actually living in another state, but I still have my place in Washington, but I'm doing my work in another state, technically, like the law requires that I update it to the address where I'm doing the work. And if the address is another state and you're not registered there, that could be a problem. And so so the remote work piece has actually made the diligence around employment a little bit more complicated because now there's these like requirements of where you need to be registered to pay unemployment taxes in whatever state your employee is working in. Whether or not you need to register to do business there is a different discussion, but at an employment level, you have to do this. And so it becomes this whole like massive endeavor on that. Usually tax advisors and CFOs, they're looking at all that kind of stuff. But that can pose to be a problem in some cases. And then more recently, I'm doing one where it was exposed that somewhere Washington had a new law where, what was it? Like the minimum salary threshold went up. And this client of mine was 2 months behind on updating it. So there's a 2-month gap where they were violating that salary requirement. And so like we had to disclose that and fix that and show that we remediated it. Like these wage and things can become very complicated after some period of time because we're dealing with so many different states and we're dealing now with a more remote workforce than we ever were before. And people are not that truthful about doing this. I remember one client of mine told me that they were using a payroll processing platform. And then I was like, are you having the employees prepare their profiles? She's like, oh, we just prepare for them. I was like, well, do you have all their addresses? She's, oh, we just put our company address for everyone. So this is a big problem because she's going to get audited big time because that's not their address. Like that's not what the state or the IRS recognizes as where they're receiving income. So that was a big endeavor for them to fix. And so like people like love remote work, but this part of it is not that easy to manage if you're a small company. And the penalty is on you. Like the requirement is on you as the employer, not necessarily the employee gets penalized too, but the employer does too, but you have no way of knowing unless they tell you, so like you have to do your role in all of this. And then you have to collect all the proper records, all the I-9 records. I had one client in business for 20 plus years and they had hundreds of employees over the years and they never completed I-9 forms from any of them. And just for those listening, I-9 is the form you fill out. You might recall if you ever had a job where you show that you're authorized to work in this country, your passport, driver's license, whatever. And you have to that's a big immigration issue. And can you imagine, they've been around for so many years and it never came up. I'm like, how is this possible? So the reason I'm giving this example is no matter how small, like one founder, one employee till 25 years in business and hundreds of employees later, these same issues can impact both. So just because you're a novice doesn't mean someone just as experienced isn't running into the same thing. So like running businesses is not easy. There's so many different things you have to do to keep it in this place, especially if you really want to get to that exit. And the time that like it really shows up what you did and didn't do is due diligence. So like you don't want to show up red-faced in that process.
So to that point, like I want to be prepared, especially when things are hot and I'm about to get the check, it can get really intense. How do I keep track, for example, like that I didn't pick up an I-9 from somebody? Like, how do I protect myself from day one? Like, what are those safeguards that
But
Let
people do,
me.
I don't know. Well, not so much safeguards, but it's like, to the extent you have checklists, to the extent you can do audits for yourself. Some people like want to use their funds to get audited, do them prepare in advance for this. But if you're going to have an exit, it's not usually just like arbitrary. It's usually planned. And so like in advance of that planning, we might do some pre-planning just to do a review of everything to make sure that you're ready to go. And due diligence will take some time. And so like you want to have good counsel working with you to kind of help you prepare for this, along with the tax piece and all that kind of stuff. So it's not that I'm not trying to say that you have to do everything correct from the beginning. There is some lax to it. But the thing is, if you do have these things in mind, don't be too lax about it. And to the extent that you can stay prepared, do what you can within reason. I don't want this to be the reason you're not like focused on your business because we get caught up over here. Like it's all like all of it is just part of it. And at some point, maybe you get like some administrative help and you delegate this to them. And we work with lots of people's operations person to help them keep it. And their job is literally to keep all that stuff organized. So delegate wherever you can. So because the founder is doing too much as it is. And so like you need a trusted person that's advising you on this place on the way. And then you also need to be able to delegate some of these things. And don't be too scared of due diligence. If your company, the value is there, the buyer will buy the company and will do this. It's not going to be a board consent missing that keeps them from doing that. It's just going to be their lawyer racking up the bill to make that happen. To be honest with you, sometimes it gets to be too much from the legal side. And I see it and I tell my client, like, go talk to your business counterpart. Tell them it's getting to be too much and be like, are you in this deal or not? Be frank with them. Because once the business people get involved, they're totally fine. It's often the lawyers can get bogged down on all these things where some of these things you're like, really, this is what's bothering you? Like, let's move on from this. And the business people, 99% of the time, just like want to move on and get the deal done, like focused where it is, and then they'll go talk to their lawyers and everything will settle down a bit. And I have to do that. I tell them, I was like, I can't get this lawyer to let this issue go. I don't believe it's a non-issue. Here's the reasons why. Please go discuss on your end, and you need an advisor who can tell you that and be frank with you, not just keep battling it out,
Awesome. So we've talked a lot about a lot of things to prepare for an exit. As we wrap up, what would you say are the top 3 things founders should keep in mind when they're building their startup, preparing for an exit?
The number one thing is, I guess a couple of different things. I think it's don't ignore the paperwork. The paperwork can be really valuable to you. If it's not today, it will be valuable to you in the future. So if you do want to have that exit and be as successful as the product you have in mind, like don't ignore the paperwork. Make sure that you're taking care of your team, because if they do not feel taken care of, even when it comes to the paperwork and things like that, it's not going to end well. And that's a big exposure point for you if it doesn't end well in the plans. And pick good advisors who are helping you, who know the industry, who know the way that tech companies work. Do not pick like an accountant who's never worked with a startup before. Pick someone who's aware of these issues that come up that are common, or someone who can advise you along the way, and surround yourself with good advisors, like putting away the legal, CPA, everybody else, like good advisors, mentors, like take the time to learn the stuff that you need to be doing, because it's not right for you to just share all this stuff and then not know anything that you're doing either. Like you need to have some level of knowledge for it. And I think this podcast is a great way to do that, because even just buzzwords like 83B, QSBS, vesting, even if you don't know what that means, but these are things to go look up and learn about, because you want to be thoughtful in what you're doing. So I really feel like advisors and mentors, like the journey should not be alone. There's so many great entrepreneurial organizations, so many great places you can get this support from. And those people should know. They should be able to tell you the good, the bad, the ugly, like what worked, what didn't work, and learn from their failures. Because they'll tell you, they're like, I met this guy recently. He had an LLC throughout, and he sold the company. And his big plan was to just write all of his employees a check. And so, yeah, he might have been writing $1 million checks, but those people only saw what, 500,000-600,000 of it, like if that. And he didn't realize that by not getting them set up with equity in the beginning, He's
Ordinary income is the absolute worst way to get taxed.
ordinary income is a killer. And like he thought he was doing the right thing. And I was like, how did no one tell you about this like throughout this process? Like, how did this never come up? And it's just a little shocking when you see that because you're just like, how did this never come up? But then I'm always like, I feel like it did come up and it maybe just got ignored. I don't know. Who knows the real story? But I feel like it's on, if you have the idea, you want to bring people into your idea, you're setting the vision, you're the founder, you also have to do these. While it's not your favorite thing, you still have to do these things. And if you don't want to make it your favorite thing, you have to delegate it. Don't let it linger. Don't end up where people are like, oh, how do I give stock to people 5 years ago? Like it doesn't work that way. There's only so much you can fix in the past. You can only kind of be proactive for the future. So
awesome. This has been
so hopefully you get to the exit. If you don't, at least you'll get to like hopefully some investment and some opportunities. And if it doesn't all work out, you still need all this stuff to close it down. You don't want things like after you've shut everything down to show up for you 5 years later because you didn't pay this or take care of that. It still matters if it doesn't work out either too.
The right thing to do, in short, right? So we do it because so this has been amazing. So anything that I should have asked on the topic that we didn't cover that you think is worth bringing up?
I don't. No, I feel like you covered quite a bit. This is probably more because everything we talked about is usually like a separate session when I'm doing these on panels. And to like consolidate into one is nice because there's a way to weave it all together. But people want to know like where AI fits into all this and like how much it can do to help you. So like it can be a good resource. It could create that checklist for you perhaps, or diligence checklist and things like that. But I tell people like, I remember when, not way back when, but like a year or so ago when they're like, oh, AI is going to take everybody's job. And the first one I used to say is lawyers. AI is going to take all the lawyers' jobs. And now it says, what jobs will AI not take? It's lawyers because they tried it and it's not as great as people think it is when it comes to like proper legal work. And so like it's useful for checklists and lists like that, but it's not a way to build your agreements. I can always tell when somebody used ChatGPT. It's very obvious. And it's because it's learned on like online forums, and the online forums are not great. Like pulling from certain places that have posted all this stuff, they're not good. They're not the best of forums. They're definitely not the best of forums when it comes to startups. There are some really good resources that are online and affordable, and I'm happy to share that with your audience. And I could send you some links that I would be like, if you use these and then come to me after that, I'd be like, great, at least you use something good. But if you don't, if you use some like the generic stuff out there for your startup, it's not gonna end well. So don't necessarily use it as part of your learning, but don't rely on it for your paperwork piece of it.
Awesome. So we'd love to have that list whenever we can send it over. And thank you very much for a great conversation. I'm sure this was very informative to me on many levels, and I'm sure it will be to many more people. So, Madhu, it was a pleasure having you, and thank you so much.
Thank you.
And that's a wrap for today. Thank you for tuning in. If you find these conversations helpful in your own journey, please subscribe to Seed to Success, our weekly community letter with tips, insights, resources, and more. If you have any other questions relating to startup finance or financial storytelling, send them over to me at chakras@achieve.co. That's chakras@achiiv.co. We'll see you on the next episode of Invisible Ink. Now, go achieve.